The U.S. Attorney General not letting the Supreme Court stand in his way of going after states who make it harder for minorities to vote. It is Thursday, July 25th. Welcome to Lunch Break. I'm Wendy Bounds. Devlin Barrett joins us right now from Washington, D.C. The Attorney General Eric Holder making himself pretty clear today. What did he say, Devlin, in no uncertain terms?
Hi, Wendy. Yeah, he basically said that despite and in some ways because of the Supreme Court decision earlier this summer, his office is going to be very aggressively pursuing civil rights cases, starting with Texas over a redistricting issue, essentially. But that he's basically saying the Supreme Court may have knocked down a key part of this law, but that is only going to make us more aggressive in using the other parts of the law to go after what the Obama administration views as discriminatory voting laws.
Let's have a little legal refresher course here. 1965 Voting Rights Act, the Supreme Court struck down part of that, which has to do with pre-clearance, water cooler talk. Tell us what that means.
Yeah, it's a technical thing. Essentially, the part that was struck down was a part that said the following states and locations, because they have a history of discrimination against minorities, have to get Justice Department or court approval before they make significant changes to their voting rules. Now, what that meant in practice was that southern states often had to essentially check with Justice and sort of prove to Justice that any changes they made to the voting laws would not unequally hurt minority voters. Now, why this is relevant now is there's all these essentially voter ID laws that are being passed in a lot of states, and the Obama administration is very critical of a lot of these laws. And what Holder is talking about today is actually about redistricting, but he's also signaling something, and he's signaling that they are going to be aggressive in looking at these voter ID laws, even with the Supreme Court decision. So
what are the legal teeth he has to do that with, Devlin? I mean, is there a part of the Voting Rights Act left that can allow him to sort of still pre-clear a state like Texas?
Right, there is, and it's called Section 3 of the law. And essentially what it says is that if the courts have made a recent determination that there was a discriminatory voting practice in a state, let's say, they can essentially decide on their own that the state needs to be pre-cleared from now on going forward on voting changes. And that usually means, that can often mean something like a 10-year period where that state still has to be in pre-clearance. Now, what's interesting about it is because the government had usually used the older part, the other part of the law, there isn't a lot of case law on Section 3. So we're in a kind of a new area, and I think there's going to be a lot of legal fights, and we're going to need to see some cases play out to understand exactly how judges will use Section 3 going forward.
Any early backlash, Devlin, to the Attorney General's comments today?
We've got calls out to Texas officials in particular because obviously they're first up on the list, let's say. And we haven't heard back yet, but it's going to be an interesting dynamic because Texas has long argued two things. One, that their laws are fair and not discriminatory and they should be allowed to put them into effect. But also, two, that the Voting Rights Act was outdated, and if you wanted to challenge them on these issues, you should use something like Section 3. Now, presumably, Texas still believes that its laws are fair and just, but they are also now getting, in part, one of the things they argued for, which is, well, let us use this other part of the law to fight our case out. So it'll be an interesting dance, I think, legally as to how they proceed through this.
Yeah, definitely passionate voices on both sides of the issue. We'll continue to follow it with you guys in D.C. Thanks so much, Devlin.
Thanks, Wendy.
All right.